Dressed, he's ready.
Okay, good. Let me tell everybody else, good morning. Welcome to Lexington County and to the Lexington County Courthouse.
Crank up, getting it quick. Getting it next day is bothersome as and maybe back. We understand that. We're going to put up with that.
Okay.
That's not a problem. However, we have retained some experts, and at some point we're going to
Just
need
let me know.
and they've done this in the past.
And we'll try to work around that.
Thank you, Your Honor.
Okay, we'll make sure it gets done. All right, if y'all don't mind, I've got how I want to
Before
do
this hearing even gets into the major legal disputes, pay attention to what is happening behind the scenes, because in a high-stakes criminal case, the courtroom isn't just about dramatic testimony. It is also about procedure, evidence, deadlines, access to the accused, and whether both sides are getting the information they are legally entitled to receive. Today, the judge is dealing with a long list of motions involving Alex Murdaugh's defense, the prosecution, discovery, expert access, and potentially significant evidence issues. And there is already a subtle warning sign. The court is talking about orders not reaching everyone who needs them, including an order concerning whether Murdaugh could appear without shackles. That may sound like administrative housekeeping, but courtroom procedure matters, especially when the stakes are this high. Then we move into discovery, where the defense raises an issue that could become much more serious. Whether the prosecution has disclosed everything it is required to disclose about potential witnesses and credibility problems. And that's where today's hearing starts getting really interesting. Because once the defense begins asking why a particular witness's criminal cases have remained unresolved for years, the obvious question becomes, is there something behind the scenes that the defense hasn't been told? Is there a cooperation agreement? An understanding? Or is there another explanation entirely? Stay with this one, because we're about to see exactly how the defense puts that question on the record, and why the details could matter.
Court's now in session. Honorable Judge Deborah McCaslin presiding.
Please be seated. Good morning.
Morning. Your Honor, may we have our client brought out, please?
Absolutely.
Thank you. He's dressed, he's ready.
Okay, good. Let me tell everybody else, good morning. Welcome to Lexington County and to the Lexington County Courthouse. As soon as we get Mr. Murdaugh brought out, we'll get started. Mr. Waters, how are you?
Judge, how are you today?
I'm good. While we're waiting, let me introduce y'all to my new law clerk. This is my old law clerk. This is his last day. So you will not be emailing him anymore. This is Mary L. McKissick, and she will be the new law clerk that y'all will be getting emails from. So just wanted to introduce her so y'all would know when you did get them.
Your Honor, while we're waiting for Mr. Murdaugh, could I address one administrative thing? I've already talked to the clerk from Colleton County. When you file an order, on some occasions, you copy us when you file it. On some occasions, if we don't get it, the order allowing him to be dressed without the shackles. We read about it in Fitz News before we were aware there was an order. If you could, I don't know whether it's over, but when you send an order to Colleton County, if you copy the lawyers, I think you've done that on every order.
Let me tell you, my office usually sends an order. I do that not only in this case, but any lawyer who appears in front of me. I send a copy of my own order. I apologize for that.
I apologize for, but once things crank up, getting it quick. Getting it next day is bothersome as, but it may be that as you make evidence, whatever. If you
absolutely. Well, I'll make sure that everybody gets a copy. Again, I apologize for that.
Nothing to apologize.
I usually do send it myself.
Thank you, Your Honor.
Mm-hmm.
Here we go. Mr. Murdoch.
Okay, you ready to get started then?
Please ready, Your Honor.
All right, well, let me just kind of do a little housekeeping here. Mr. Harpootlian, let me just address kind of what we did last time as far as making arrangements out at the Bureau of Prisons for a conference room where you could take discovery to your client. Have you had any issues with that?
Let me just confirm.
None at all.
We have no issues whatsoever. Everyone's been wonderful.
Okay, good. And then I told you that I would check on if there's any kind of download that you could do to the tablet that he has, and there's not. So we're going to have to stick with the computer from either the law clerk or one of your staff members going out to the BOP.
We are, at this juncture, we have a law clerk, this young man back here, who's going down there, and of course, 2.5 hour drive. Typically, it's 2.5, 3 hours with him, and then 2.5 hour drive back. We understand. We're willing to put up with that.
Okay.
That's not a problem. However, we have retained some experts, and at some point, we're going to need to, and they've done this in the past for us, but we've done some FaceTime meetings with them so they can show Mr. Murdaugh
I'm with you.
drawings and all those sorts of things. So we're going to try to, and I don't think they're going to have a problem with that, but if we arrange for an expert to be available and we're paying them hundreds of dollars an hour, we'd like it to work seamlessly if we can.
Well, if you have any problem, all you have to do is just let me know.
Yes, ma'am.
And we'll try to work around that.
Thank you, Your Honor.
Okay, we'll make sure it gets done. All right, if y'all don't mind, I've got how I want to do this hearing today. Because I plan to hear all of your motions except for 3. And I've kind of picked out the ones that I thought we could kind of go through right easily this morning. I know that both of you renewed your discovery motions and your reciprocal discovery motions. Let me ask the state, right now, do we have any problems with discovery?
Not that I'm aware of, Your Honor. Obviously, we have filed a motion as it relates to that defense phone extraction. That's obviously one of the things on the table today.
And I'm going to rule on that today.
We are obviously always auditing discovery, and of course, it has been a few years since the trial, so there may have been things that we would turn over that have developed since that time, and we're in the process of doing that, but we are not aware of any discovery issues at this time. Indeed, not too long ago, the defense realized that one of the original big murder downloads that we gave them back in August of 2022 had been corrupted on their end, and our staff worked and did hours and hours of work to put all of that, to provide that to them. So my understanding is that they have all that, which they had then at the time. They had
Yeah, it's certainly not anything new, just something you had to recopy and give to them. Okay. How about you, Mr. Harpootlian? Do you have any discovery issues right now?
Mr. Griffin would like to address that, Your Honor.
Mr. Griffin, be happy to hear from you.
Yeah, I'll come up here, Your Honor, since I'm on the microphone. Good morning.
Good morning.
I want to make a record. I mean, there's ongoing obligation by the state. They say that
There's an ongoing
they
obligation by both of y'all.
And so there's some items that we would have expected to receive by now, and we have not.
Let me know what those are.
Now we're
What
getting
are
into
they?
one of the most legally important parts of this hearing, discovery. In plain English, discovery is the process through which the prosecution and defense exchange information that may be relevant to the case. But the defense is emphasizing something more specific here, information that could affect a witness's credibility. The attorney refers to Giglio material, named after the U.S. Supreme Court's decision in Giglio versus United States. The basic concept is crucial. When information could show that a government witness has a credibility problem, bias, an undisclosed deal, a promise of leniency, or another reason their testimony might be viewed differently by a jury, that information can be subject to disclosure obligations. Notice what the defense is doing strategically. They aren't simply saying, "We want more evidence." They are identifying a category of information and then pointing to a specific person, Curtis Eddie Smith, whose unresolved criminal cases potentially raise questions about whether there could be an undisclosed understanding with prosecutors. That does not automatically prove that a secret deal exists. And that's an important distinction. An unresolved case alone isn't proof of cooperation. But the defense is arguing that if an agreement, promise, or understanding does exist, they are entitled to know about it. So here's the question for you. If a potential witness has serious unresolved charges hanging over him for years, should the defense be able to investigate whether that witness received, or expected to receive, some kind of benefit? That's exactly the issue the defense is putting squarely before the court.
Let me know what those are. What are they?
So, as Your Honor well knows, the state has to produce evidence, information pertaining to, that the defense could use to challenge the credibility or truthfulness of a witness. It's called Giglio material, and it's in the United States Supreme Court, Giglio v. United States, and these include plea deals and promises, secret agreements, evidence of witness bias, and credibility issues of police where there's evidence of past misconduct. And in that category, I have a few items as to secret agreements. There's a co-defendant in some cases, and then he's been charged separately. His name is Eddie Smith. Curtis Eddie Smith, who's a distant cousin of Mr. Murdaugh, was charged on November 2021, almost 5 years ago, of ab-hand, pointing and presenting, conspiracy, filing a false police report, and that's related to a roadside shooting that involved Mr. Murdaugh. Subsequently, in June of 2022, he was indicted by the state grand jury of 4 counts of money laundering, trafficking in meth, of other things. 4+ years have gone by, and those cases have not been disposed of. Every other case that we're aware of have been disposed of. And it begs the question, why not? Do they have a cooperation agreement with Mr. Smith? If so, what are those terms? He has been identified as a witness in this case since the last trial, well before the last trial.
And this is the moment where the defense's argument becomes much more pointed. They have now moved from general complaints about discovery to a very specific allegation of missing information. The status of Curtis Eddie Smith's criminal cases and whether there may be an undisclosed cooperation agreement or understanding. Look at the timeline the defense is emphasizing. Smith was charged in November 2021 in connection with allegations involving a roadside shooting, and then, according to the defense, he was later indicted in June 2022 on multiple serious charges involving money laundering, trafficking, and methamphetamine. Yet the defense says those cases have remained unresolved while other cases they are aware of have been disposed of. Again, that timeline by itself does not establish misconduct or prove that prosecutors made a deal. But legally, the defense's concern is understandable. If a witness has something significant hanging over his head, and the prosecution has made any promise or arrangement that could influence his testimony, the defense argues that information needs to be disclosed. And notice the strategic importance of making this argument on the record. The defense isn't merely asking the judge for information privately. They are preserving the issue in open court. So what do you think? Is the unexplained delay enough to justify deeper scrutiny? Or could there be an innocent explanation that has nothing to do with cooperation? The next part of this hearing is where the court's response becomes especially important.
Well before the last trial. So we've got nothing on Mr. Smith. And if they have a deal, they're obligated to disclose it. If they have an understanding, they're obligated to disclose it. And we've never received it.
So, here's where we stand based strictly on the portion of the hearing provided. The judge began with courtroom administration and logistics, including communication of orders, access to discovery materials, and arrangements for defense counsel to meet with Murdaugh at the Bureau of Prisons. The court also addressed the practical challenge of allowing defense experts to communicate with him and explained that several motions would be taken up during the hearing. The major legal issue in this excerpt, however, is discovery, particularly the defense's request for potential Giglio material concerning witness credibility. The defense specifically raised questions about Curtis Eddie Smith, his unresolved criminal cases, and whether there could be an undisclosed agreement, promise, or understanding involving his status as a potential witness. The prosecution's position, as stated earlier in the hearing, was that it was continuing to audit discovery and was not aware of outstanding discovery problems, while also noting that certain previously provided material had to be recopied after becoming corrupted. Importantly, this excerpt does not contain the judge's final ruling on the Smith-Giglio issue or the other motions, so it would be inaccurate to claim that the court ultimately granted or denied the defense's request based only on this transcript. What we do have is a clear picture of the legal battle lines: transparency, witness credibility, and the prosecution's continuing disclosure obligations. Now we want to hear from you. Do you think the defense raised a legitimate red flag, or is there another reasonable explanation for the unresolved cases? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.